October 26, 2000. A telephone call between executives at the General Reinsurance Corporation and the American International Group is recorded on GenRe's internal compliance system. On the call, the parties discuss a transaction that one participant later described in testimony as one in which AIG would assume essentially no insurance risk. The structure being negotiated would, on paper, transfer approximately $500 million in loss reserves onto AIG's balance sheet in 2 installments, in exchange for a premium designed to flow back through the same arrangement. The question this episode answers is how a transaction with no genuine risk transfer was made to look to auditors and to public markets like reinsurance. The instrument at the center of this case is called Finite Risk Reinsurance. To understand what AIG and GenRe did, you have to understand first what finite reinsurance was supposed to be and why it existed as a legitimate product before it was deployed as an accounting device. Reinsurance, in its conventional form, is insurance purchased by insurance companies. A primary insurer that writes, say, commercial property policies wants to limit its exposure to a single catastrophic loss. It cedes a portion of its premium to a reinsurer, and in exchange the reinsurer assumes a portion of the claims. If the claims come in higher than expected, the reinsurer pays. If they come in lower, the reinsurer keeps the premium as profit. Risk has been transferred. That transfer is the entire economic substance of the contract. Finite reinsurance emerged in the 1980s as a hybrid product. It blended elements of traditional reinsurance with elements of financing. The defining feature was that the reinsurer's downside was capped, finite, and the contract often spanned multiple years, with provisions that allowed premium and losses to be smoothed across the contract's life. Finite contracts could legitimately transfer risk. They could also legitimately function as a form of capital management, allowing an insurer to absorb a known loss over a longer accounting horizon. The legitimacy turned on a specific accounting test. That test was codified in the United States under Statement of Financial Accounting Standards number 113, issued by the Financial Accounting Standards Board in 1992. SFAS 113 governs how reinsurance contracts are accounted for. Its core requirement is straightforward: for a contract to be treated as reinsurance on the financial statements, meaning the ceding company can record the ceded premium as an expense and book the reinsurance recoverable as an asset against its reserves. The contract must transfer significant insurance risk. The reinsurer must face, in the language of the standard, a reasonable possibility of significant loss. If the contract fails that test, it is not reinsurance for accounting purposes. It is a deposit. The premium paid is recorded as a financial asset, not an expense. No reserve relief is granted. No surplus is created. The transaction is, in accounting terms, a wash. The practical consequence is this: an insurance company's balance sheet is dominated by 2 numbers. Its loss reserves on the liability side, representing its best estimate of claims it will eventually pay, and its surplus on the equity side, representing its capacity to absorb adverse development. Analysts watch loss reserves closely. A declining reserve balance can signal that the company is releasing reserves into earnings, that is, recognizing prior reserves as no longer needed, which boosts current income. It can also signal that the company is under-reserving for future claims. Either interpretation invites scrutiny. In the 3rd quarter of 2000, AIG reported a decline in its general insurance loss reserves. The decline was approximately $59 million. Equity analysts noted the decline in their published research. The market reacted. AIG's share price fell. What followed, according to the SEC's complaint and the consent orders filed in 2006, was a transaction designed not to transfer risk, but to reverse the optical effect of the reserve decline. AIG approached General Reinsurance, a subsidiary of Berkshire Hathaway, with a proposal. AIG would enter into a reinsurance contract with Gen Re, under which AIG would appear to assume $500 million in loss reserves from Gen Re's portfolio. In exchange, AIG would receive a premium. The premium and the expected losses would be calibrated such that neither party bore meaningful economic risk. The record establishes the architecture in detail. The transaction was executed in two tranches. The first, in the fourth quarter of 2000, added $250 million in loss reserves to AIG's balance sheet. The second, in the first quarter of 2001, added another $250 million. Total reserve impact, $500 million, recorded as ceded reinsurance from Gen Re to AIG. To understand the architecture, walk through it step by step. Step 1. The transaction was initiated at AIG's request. The SEC's order found that the deal was proposed by AIG to address market concerns about its loss reserves. The economic purpose, as established in the enforcement record, was not to assume risk. It was to produce a specific accounting result on AIG's financial statements. Step 2. The contract was structured as a retroactive reinsurance arrangement. AIG would purportedly assume responsibility for losses on a portfolio of Gen Re's business that had already been written. Retroactive reinsurance is a legitimate product. It exists. Insurance companies do sometimes transfer responsibility for prior year exposures, but for retroactive reinsurance to qualify under SFS 113, the same risk transfer test applies. The assuming insurer must face a reasonable possibility of significant loss. Step 3. The premium was set at $500 million. This is the figure that matters. The premium flowing from Gen Re to AIG was, in approximate terms, equal to the loss reserves AIG would assume. In a genuine reinsurance contract, that equivalence would be a problem. The premium reflects the expected losses, plus a risk margin, plus the reinsurer's profit. If premium equals expected losses, there is no risk margin and no profit. The structure produces no economic incentive for the reinsurer. It only makes sense as a financing arrangement or as an accounting fiction. Step 4. To address the appearance of equivalence, the parties built in additional features. According to the SEC's findings, Gen Re paid AIG a fee of approximately $5 million to enter into the transaction. The fee was small relative to the notional size of the deal. The record establishes that this fee was the actual economic substance of the transaction from Gen Re's perspective. Gen Re was not ceding risk. It was being paid to participate in a structure that served AIG's accounting needs. Step 5. The cash flows were structured to be largely offsetting. AIG received premium. AIG would, in time, pay claims. The two streams were calibrated so that the net economic exposure to AIG was minimal. The record establishes that AIG itself funded the premium it received indirectly through the structure of the cash flows. In other words, the money that came in as premium was substantially the same money that AIG had effectively committed to pay back as losses. Step 6. The accounting treatment on AIG's books recorded the $500 million as loss reserves on the liability side and the premium as a corresponding entry on the asset side. The visible effect on the published financial statements was an increase in general insurance loss reserves. The reserve decline that had drawn analyst criticism in the third quarter of 2000 was reversed in subsequent quarters. The market's specific concern was addressed. What had been done, structurally, was the manufacture of reserves. Reserves are supposed to represent an estimate of claims liability. Here, the reserves represented nothing of the kind. They represented a circular cash flow dressed up as insurance. The transaction was approved at senior levels within both companies. The SEC's complaint named, among others, the Chief Executive Officer of General Reinsurance, Ronald Ferguson, and the Chief Financial Officer of AIG, Howard Smith, along with other executives. The criminal indictments that followed in the Eastern District of Connecticut named 5 executives, 4 from Gen Re and 1 from AIG. The record shows that the transaction was negotiated, documented and approved with knowledge at the senior executive level of both parties that the structure did not transfer significant risk. The October 2000 telephone call referenced at the start of this episode was central to the criminal case. The call was recorded on Gen Re's compliance system and the recording was preserved. In the call, the parties discussed the structure of the transaction in terms that established, according to the prosecution's case at trial, that the participants understood the deal had no genuine risk transfer purpose. The jury, in February 2008, returned guilty verdicts on charges of conspiracy, securities fraud, mail fraud, and making false statements to the SEC. Those convictions were later vacated by the Second Circuit Court of Appeals in 2011 on grounds related to evidentiary rulings and jury instructions. The case was remanded. Following remand, the defendants entered into agreements that resolved the criminal matter without the original convictions standing. The civil enforcement record, however, remained intact. The SEC's consent orders, AIG's restatement, the corporate settlements. Those parts of the record were not disturbed. In February 2006, AIG entered into a settlement with the SEC, the Department of Justice, the New York Attorney General's Office, and the New York State Department of Insurance. The aggregate settlement amount was approximately $1.64 billion. The Gen Re transaction was one of several accounting issues addressed in the settlement, but it was the most prominent. As part of the settlement, AIG agreed to restate its financial statements. The restatement reversed the accounting treatment of the Gen Re transaction. The $500 million in reserves came off the balance sheet. The transaction was reclassified as a deposit rather than as reinsurance. The structural question that follows is why detection took so long. The transaction was executed in late 2000 and early 2001. The restatement came in 2005. For approximately 4 years, AIG's published financial statements reflected reserves that had no economic substance behind them. Auditors signed those statements. Analysts modeled them. Rating agencies relied on them. The detection failure operated at several levels. At the audit level, the question was whether the external auditors examined the Gen Re transaction with sufficient skepticism to identify the absence of risk transfer. The accounting standard, SFS 113, places the burden on the reporting entity to document that risk transfer is present. The standard does not specify a single quantitative test. It uses language about reasonable possibility of significant loss. In practice, the industry developed informal benchmarks. the so-called 10-10 rule, under which a contract was generally considered to transfer risk if the reinsurer had a 10% chance of a 10% loss. The 10-10 rule was never formally adopted by FASB. It was an industry shorthand. The structural problem with the 10-10 rule and similar benchmarks was that they invited engineering. A contract could be designed to pass a quantitative threshold while still being structured, so that, in expectation, the reinsurer faced negligible economic risk. The tail scenarios could be made to satisfy the test even when the central case made the contract a wash. The Gen Re transaction was not, on its face, an obvious failure of the 10-10 rule. It was a transaction whose risk transfer features were engineered for documentation purposes. At the audit level, then, the question was not whether the contract documents looked like reinsurance. They did. The question was whether the auditor's review of the underlying economics, the cash flows, the offsetting features, the side agreements, would have revealed that the substance differed from the form. The SEC's enforcement record establishes that AIG's accounting for the transaction was not supported by the substance. It does not establish that the auditors had access to the full set of communications that documented the parties' understanding of the deal's purpose. At the regulatory level, state insurance regulators in New York and elsewhere have authority over insurance company solvency and reserve adequacy. They examine the financial statements. They review reinsurance contracts. The detection failure at the regulatory level was structural in a different way. Insurance regulation in the United States operates state by state. AIG was a global insurance group with thousands of subsidiaries. The reinsurance transaction was booked through specific entities, and the consolidated impact appeared at the group level. The regulators with jurisdiction over individual entities were not necessarily positioned to evaluate the consolidated effect. At the analyst level, the original criticism in 2000 that drove the transaction came from sell-side equity analysts who noticed the reserve decline. The same analytical community then watched the reserve build in subsequent quarters and, according to the record, did not pursue the question of how the build was achieved. The reinsurance disclosure in AIG's filings did not identify the Gen Re transaction with specificity. The aggregate ceded reinsurance figures were consistent with the company's stated business mix. At the rating agency level, AIG carried AAA ratings from the major agencies for most of this period. The Gen Re transaction did not, by itself, materially affect the rating analysis, because the rated entity was the AIG insurance group as a whole, and the $500 million was a relatively small figure against the group's total reserves and surplus. The rating agencies relied on the audited financials. What would have had to be true for detection to occur earlier? Several things in combination. The auditors would have had to examine not only the contract documents, but the contemporaneous communications between the parties about the purpose of the transaction. The recorded telephone call from October 2000 was not part of the audit evidence. It became part of the evidentiary record only when prosecutors obtained it through subpoena years later. The structural weakness here is that audit evidence is largely document-based. Communications that establish intent, the discussions of why a transaction is being structured a particular way, are not typically part of an audit file unless something prompts inquiry. regulatory examination would have had to extend beyond the form of the contract to the substance of the cash flows over the contract's life. By the time the cash flows had played out, the accounting had been baked into multiple years of financial statements. Real-time detection would have required examiners to model the expected cash flows at inception and compare them to the represented risk transfer. This is not routine examination practice. The detection that did occur came from a different direction. In 2004, the New York Attorney General's office, under Eliot Spitzer, opened an investigation into insurance industry practices. The investigation focused initially on bid rigging in the commercial insurance brokerage market, but it expanded. In early 2005, the investigation reached the finite reinsurance market, and specifically reached the Gen Re transaction with AIG. The unraveling proceeded in a specific sequence. In February 2005, AIG and Gen Re both received subpoenas from the SEC and from the New York Attorney General's office concerning the use of non-traditional insurance products to manipulate financial statements. The subpoenas identified the Gen Re transaction by reference among other transactions. In March 2005, AIG's board of directors initiated an internal review. The board engaged outside counsel and accountants to examine the transactions identified in the subpoenas. The internal review identified accounting issues with the Gen Re transaction and with several other transactions at AIG. Also, in March 2005, AIG announced that its chief executive officer, Maurice Greenberg, would step down. The company stated that the change was in connection with the ongoing investigation. Greenberg was not at that time charged with any crime. The SEC later filed civil charges against him in 2006. Those charges were resolved by settlement in 2009, in which Greenberg paid $15 million to settle SEC allegations without admitting or denying the underlying findings. In May 2005, AIG announced that it would restate its financial statements for the years 2000 through 2004. The restatement reduced AIG's net worth by approximately $2.7 billion. The Gen Re transaction was a significant component of the restatement. The accounting for that transaction was reversed. The $500 million in loss reserves was removed, and the cash flows were reclassified as a deposit rather than as reinsurance. In June 2005, the SEC filed civil enforcement actions and proceedings began that would lead to the comprehensive settlement in February 2006. The settlement, totaling approximately $1.64 billion across federal and state authorities, was at the time one of the largest corporate settlements in US history. Gen Re separately entered into a deferred prosecution agreement and paid approximately $92 million in a related settlement. In February 2006, federal prosecutors in the Eastern District of Connecticut obtained a grand jury indictment of 5 executives in connection with the Gen Re AIG transaction. The defendants were 4 former Gen Re executives, including the former Chief Executive Officer Ronald Ferguson and 1 former AIG executive. The indictment charged conspiracy, securities fraud, mail fraud, and false statements. The trial took place in early 2008. The jury heard the recorded telephone calls, including the October 2000 call. The jury heard testimony from Gen Re employees who had worked on the transaction and who described its structure. The prosecution's theory was that the defendants knew the transaction was not genuine reinsurance, structured it to produce a specific accounting result for AIG, and concealed its true purpose from AIG's auditors and the investing public. In February 2008, the jury returned guilty verdicts on all defendants on all counts. In August 2011, the Second Circuit Court of Appeals vacated the convictions. The appellate decision was based on evidentiary issues including the admission of certain stock price evidence and aspects of the jury instructions. The court ordered a new trial. Before retrial, the government and the defendants reached resolutions that did not require the original convictions to stand. Several defendants entered into non-prosecution agreements or pleaded to reduce charges. The criminal case did not produce a final set of convictions. The civil enforcement record, however, was not affected by the appellate ruling. The consent orders with the SEC remained in place. AIG's restatement remained in place. The accounting treatment of the Gen Re transaction was and is in the public record as having been improper. The unraveling of the transaction, in mechanical terms, was the reversal of the original accounting. When the deal was reclassified from reinsurance to deposit, the $500 million in reserves came off AIG's balance sheet. The optical effect that the original transaction had produced, the reversal of the reserve decline that had concerned analysts in 2000, was itself reversed 5 years later. The market had, in the interval, priced AIG's securities partly on the basis of financial statements that did not accurately represent the company's reserves. What does this case establish about the mechanism? It establishes that finite reinsurance as a category of contract was susceptible to engineering. The standard governing reinsurance accounting, SFS 113, used a principles-based test for risk transfer. The principles-based test was a deliberate choice by the standard setters. It allowed flexibility for legitimate transactions that did not fit a rigid quantitative threshold. The same flexibility in the Gen Re AIG case allowed transactions structured to satisfy the form of the standard while violating its substance. The case also establishes that the detection of accounting manipulation through structured insurance products required evidence that was not typically present in audit files. The recorded telephone calls that established the parties' understanding of the transaction's purpose were the central evidence in the enforcement and criminal proceedings. Without that evidence, the transaction's documentation alone might have continued to support the original accounting treatment. Following the AIG Gen Re case and several contemporaneous cases involving finite reinsurance, the regulatory and accounting response moved in specific directions. The SEC and state insurance regulators issued guidance addressing the use of finite reinsurance products. The accounting profession revisited the application of SFAS 113. The standard itself was not rewritten, but the documentation requirements around risk transfer were tightened in practice. Reinsurers and ceding companies began requiring more substantial contemporaneous analysis of expected cash flows and risk transfer. In 2008, the National Association of Insurance Commissioners adopted revisions to its model regulations addressing finite reinsurance, including enhanced disclosure requirements for contracts that did not meet certain risk transfer benchmarks. Insurance companies became required to certify in their statutory filings that reinsurance contracts treated as risk transferring did in fact transfer risk under the applicable accounting standards. The Sarbanes-Oxley Act of 2002, which had been enacted before the AIG Gen Re transactions were unwound, imposed certification requirements on corporate officers regarding the accuracy of financial statements. The certifications by AIG's officers during the period when the Gen Re transaction was reflected in the financial statements became part of the basis for the enforcement actions that followed. Sarbanes-Oxley did not prevent the original transaction. It did contribute to the framework under which the transaction's misrepresentations were prosecuted. The structural observation that closes this review is this: reinsurance accounting depends on the substance of risk transfer. When the parties to a reinsurance contract share a common understanding that risk is not being transferred, and when that understanding is documented in contemporaneous communications, the contract's form is insufficient to support the accounting treatment. The verification chain that surrounds public company financial reporting, auditors, regulators, rating agencies, analysts, is built around documents that represent the form of transactions. Where form and substance diverge by design, the verification chain depends on whether the divergence becomes part of the documentary record that gatekeepers can access. In the AIG Gen Re case, the divergence was recorded. The telephone calls existed. The compliance system at Gen Re preserved them. The evidence that established the transaction's true purpose was generated by the same internal controls that, in a different scenario, might have prevented the transaction from occurring. The record establishes that the transaction was approved despite the existence of those controls, and that the controls became the basis for the eventual enforcement only when external investigators obtained the underlying recordings. The $500 million in reserves that appeared on AIG's balance sheet between late 2000 and 2005 represented, in substance, nothing. The cash flows that supported the reserves were circular. The risk that supposedly justified the reinsurance accounting was, in the parties' contemporaneous understanding, not present. What had been built was a structure designed to satisfy a reporting requirement without satisfying the economic condition that the requirement was meant to verify. The case is, in the forensic sense, complete. The accounting was restated. The settlements were paid. The civil findings stand. The criminal case did not produce a final set of convictions, but the structural record of what occurred is established in the consent orders, the restatement, and the trial evidence that remains part of the docket. The finite reinsurance mechanism continues to exist as a product. Its use is now constrained by tighter documentation, by enhanced certification requirements, and by the prosecutorial record that the AIG Gen Re case left behind. That record is the finding. The mechanism was the manufacture of reserves through a circular reinsurance structure. The detection failure was the gap between document-based verification and intent-based evidence. The unraveling was a state attorney general's investigation that expanded from an adjacent market and reached the recorded communications that the original verification chain had not examined. The structural close is that finite reinsurance as an instrument requires both the form and the substance to align. When they do not, and when the divergence is documented, the record will eventually show what the balance sheet did not.